Good evening. My name is Julie Gustafson, and we are here because of programming that we have arranged to do because of the Lincoln, the Constitution, and the Civil War exhibit that we brought on campus. The library received a grant to do that. The College of Wooster Library did. And we are partnering with Wayne County Historical Society, Worcester City Schools, and the Center for Diversity and Inclusion here on this campus. And I would like to introduce our panel and our moderator. I will start with Josephine Wright. She is the panel moderator, and she's professor of music and the Josephine Lincoln Morris Professor of Black Studies, Department Chair of Africana Studies here at the College of Wooster. Our panelists are Margo Broehl. She's in the middle of the two panelists over there. She will be the first to speak. She's lawyer at the Broehl Law Office located here in Worcester, and she's also a 1970 alum. The second speaker is Evan Riley. He's assistant professor of philosophy here at the College of Wooster, and he has taught themes in continental philosophy, philosophy of mind, 19th century social critics, ethics, philosophy of law, as well as political philosophy. And our last panelist is Douglas Drushal, lawyer at Critchfield and Johnston attorneys located here also in Worcester. And I think I'm going to leave it at that and let our panel begin. Thank you.
Thanks, Joy.
Good evening. Tonight we're looking at the 14th Amendment. Like all stories in history, this one has human faces behind it, which you won't see until tomorrow, but they're here. And like most stories in political history, this one is founded on power and greed. The first section of the amendment is the one that garners most attention, but our story has roots in section 2, the dull topic of apportionment. Why is this important? Because apportionment decides how many representatives a state may have in the House of Representatives at Congress. And in the Constitution, the House was given the power to introduce laws and legislation that specifically dealt with revenue and taxes. So, we begin our story with the Constitution. Each state had its own constitutional convention to select the delegates who would vote on ratification. Let's look at who here would have been able to vote for those delegates. Raise your hand if you're over 21. Keep it up if you're a citizen. Keep it up if you own property. That means real property on which you pay tax. Native Americans can put their hands down because their land was not taxed. Hands down if you're a non-Christian. No Jews, no Muslims, no Buddhists, and for the right to vote in this election, no Quakers, no Baptists, no Catholics. Are you white? Are you male? We're looking at a minority. You may put your hands down. If you're the person paying the taxes, and clearly in the minority, you do not want the majority to be able to tell you how much tax you're going to pay and how that tax will be spent. Now, the map that I'm showing you here of the United States in 1787 shows the states. There were 8 free states, or 8 slave states and 5 free states. That gave the slave states the majority in the Senate. That gave them a 62% majority. Adding the free states in the Northwest Territory was intended to even up this participation in the Senate. Next, we have a chart that shows the population at the first census in 1790. That shows that the slave states were going to have a minority in the House of Representatives based on the white population. How to get around that? Give credit for the slave population, but only for the purposes of apportionment, and only to grant them as 3/5 of a person. You will see that that increased Virginia alone's House members from 12 to 19 and kept the South with a majority in the House. After 1790, new states were often admitted to the Union in pairs to maintain a balance in the Senate. By 1847, the map contained states that extended beyond the Mississippi River. By that time, most of you men over 21 could have voted, some women who owned property, and in free states, freed slaves could vote. Our first hero now enters the picture. Dred Scott was born about 1799 to a slaveholding family named Broehl. The Broehl family moved from Virginia to Alabama in 1818. With their fortunes greatly reduced, they relocated to Missouri in 1830, and they sold Dred Scott to an Army doctor named Emerson. Army officers moved frequently, and Dr. Emerson took Scott with him to each posting. In 1836, they went to Fort Armstrong in the Free State of Illinois. In 1837, they went to Fort Snelling, which was then in the Free Wisconsin Territory. This would now be a piece of Minnesota. There, Dred Scott met and married a woman named Harriet Robinson. She was owned by a man named Lawrence Taliaferro, who was a justice of the peace. He formalized their marriage in a civil ceremony. Since slave marriages had no legal sanction, supporters of Scott would later say this ceremony was evidence that he was being treated as a free man. Nevertheless, Taliaferro transferred Harriet to Emerson, and who treated the Scotts as his slaves. Emerson was posted back to St. Louis in 1837. This time he left the Scotts behind in the Free Territory of Wisconsin and leased them out to other officers. In February 1838, Emerson met and married Eliza Irene Sanford in Louisiana, whereupon he sent for the Scotts to join him. While on a steamboat on the Mississippi River between the Free State of Illinois and the Iowa District of Wisconsin, also free, Harriet Scott gave birth to their first child, whom they named Eliza after their mistress. The Emersons and the Scotts returned to Missouri in 1840. In 1842, Emerson left the Army. He died in Iowa in 1843. His wife, Irene, inherited his estate, including the Scotts. For 3 years after Emerson's death, she continued to lease the Scotts out to other people as hired slaves. In 1846, Dred Scott wanted to purchase his freedom and his family's freedom, and Irene Emerson refused. This prompted Scott to resort to legal action, and in 1846, he filed a suit in the St. Louis Circuit Court. One of our heroes now enters, Henry Taylor Broehl, yes, the son of Scott's original owner, who joined with his siblings to support Scott and to fund the litigation. Scott stood on solid legal ground, as Missouri precedent dating back to 1824 had held that states freed through prolonged residence in Free State would remain free when taken back to Missouri. The doctrine was known as once free, always free. Scott and his wife had resided for 2 years in free states. His eldest daughter had been born on the Mississippi River between a free state and a free territory. Scott v. Emerson was tried in 1847 in St. Louis. The verdict went against him on a technicality. Irene Emerson quickly filed to have the Scotts put under the control of St. Louis sheriff. For almost 10 years, until 1857, Dred Scott and his family were in the sheriff's custody, who hired them out and collected and kept their wages until the freedom suit was resolved. The Scots attorney filed a motion for retrial, which was granted. The case was again heard in January 1850 when the all-white jury found for Scots freedom. Irene Emerson appealed. In 1852, the Missouri Supreme Court, by a vote of 2-1, struck down the lower court ruling, finding that slaves could obtain their freedom when taken to free states, but that slavery status reattached upon return to a slave state. In 1853, Scott again sued, this time under federal law. Irene Emerson had moved to Massachusetts. Scott had been transferred to the control of her brother, John Sanford, who was a citizen of New York, while Scott, if freed, would be a citizen of Missouri. That gave the federal courts diversity jurisdiction over the case. After losing again in federal district court, the Scots appealed to the United States Supreme Court in Dred Scott v. Sanford. And now enters the villain of the piece, Roger Taney, Chief Justice of the U.S. Supreme Court, which finally heard the case in 1857. The court found against Scott, stating that he was not a citizen. At best, he was personal property who could not be taken from his owner by state action without the compensation guaranteed by the Fifth Amendment. The court also determined that Congress did not have the authority to prohibit slavery in the territories. His majority opinion, in what is deplored as one of the worst decisions of the court in history, was inflammatory. He noted that African Americans, free or slave, had not been considered part of the original community of people covered by the Constitution, but people of an inferior order. Because they were originally excluded, he contended that neither the court nor Congress could now extend rights of citizenship to them. The text of his statement reads, "In the opinion of the court, the language used in the Declaration of Independence shows that neither this class of persons imported as slaves nor their descendants, whether they had become free or not, were acknowledged as part of the people nor intended to be included. They were regarded as beings of an inferior race and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit." 4 years after Chief Justice Taney read his infamous Scott v. Sanford decision, parts of the pro-slavery half of the Union had seceded, and the nation was engaged in civil war. The Dred Scott decision served as an eye-opener to Northerners who believed that slavery was tolerable as long as it stayed in the South. But if the decision took away any power Congress once had to regulate slavery in new territories, it could quickly expand into much of the western United States. And once slavery expanded into the territories, it could spread just as quickly back into the once free states. Northerners who had not previously been against the South began to realize that if they did not stop slavery now, they might never again have the chance. The country finally realized that, as Abraham Lincoln had said, a house divided against itself cannot stand. This government cannot endure permanently half slave, half free. Slavery was abolished in 1863, but the Dred Scott remained an impediment to the rights of freed slaves. Black codes enacted by the southern states denied equal rights to freed slaves. These black codes restricted black people's right to own property, to conduct business, to buy and lease land, and to move freely through public spaces. A central element of the black codes were vagrancy laws. States criminalized black men who were out of work, who were not working at a job whites recognized. Failure to pay a certain tax or to comply with other laws could also be construed as vagrancy, an imprisonable offense, with those prisoners supplied to local governments and planters as convict workers in miserable living conditions. Now enters our final hero, Representative John Bingham from New Philadelphia, Ohio. Bingham drafted the 14th Amendment, which effectively overturned the Dred Scott decision by granting citizenship to those born in the United States, requiring due process for all citizens, and imposing penalties on any southern states that did not provide equal voting rights for black citizens. The other members of the panel will talk more about what happened with the amendment itself, but I close with what happened to our leading characters. Henry Broehl bought the Dred Scott family immediately after the decision and freed them. Dred Scott had 16 months of freedom before he died of tuberculosis. Following a successful career in business, Henry Broehl had a political career, including serving on the drafting committee of the 14th Amendment. John Bingham continued in Congress until appointed as the ambassador to Japan, where he served under 4 presidents. And Roger Taney? These are the words of Justice Scalia in his dissenting opinion in Planned Parenthood v. Casey. There comes vividly to mind a portrait by Emanuel Gottlieb Leutze that hangs in the Harvard Law School. Roger Brooke Taney painted in 1859, the 82nd year of his life, the 24th of his chief justiceship, the second after his opinion in Dred Scott. He is all in black, sitting in a shadowed red armchair, left hand resting upon a pad of paper in his lap, right hand hanging limply, almost lifelessly, beside the inner arm of the chair. He sits facing the viewer, staring straight out. There seems to be on his face and in his deep-set eyes an expression of profound sadness and disillusionment. Perhaps he always looked that way, even when dwelling upon the happiest of thoughts. But those of us who know how the luster of his great chief justiceship came to be eclipsed by Dred Scott cannot help believing that he had that case, its already apparent consequences for the court, and its soon-to-be played-out consequences for the nation, burning on his mind. He died in 1864. Kevin?
I'm going to do something a little bit different. That is, I want to look in particular very closely at the Equal Protection Clause. And so that's going to be at least the sort of center idea that I want to focus on. So we're going to take a deep dive, I'm hoping, into one particular and important part of Section 1 of the 14th Amendment. What is the Equal Protection Clause of the 14th Amendment supposed to ensure? The very short answer, it's supposed to guarantee basic equality before the law in the US. The laws of the states and local authorities are to be equally protective of the fundamental rights of any person, and so apply equally to all persons under the jurisdiction of those states or local authorities. This clause addresses the rights of all resident persons. It is not even restricted to citizens. As it says, we are not to deny, quote, to any person within its jurisdiction the equal protection of the laws, right? So that's the last clause of Section 1, which you have. In my limited time, I want to make 3 points. First, I want to reflect on why we should think having a fundamental commitment to equal protection of the laws is a good thing, and indeed is something justice demands of all decent systems of law. This is a general point. Second, I want to raise the possibility that the way this commitment to equality before the law frequently gets interpreted in practice in our system is too weak. This is to make the case for embracing a more robust ideal of equality before the law. Here I appeal to an imaginary case and draw some distinctions that are supposed to help us think clearly. third, and very briefly, I want to suggest, given the first 2 points, that we think about 2 particular ways that this more robust ideal of equality before the law gets violated. One violation has to do with the history of women's suffrage in the US, and the second has to do with what Michelle Alexander calls the new Jim Crow. The first point. A primary point of the 14th Amendment was to prevent and redress using the law unjustly against African Americans following the Civil War. People of African ancestry across the South, though freed from slavery by the time of ratification, were not yet properly and securely legally recognized as the persons they were in fact. Indeed, even following ratification, new state and municipal laws were used to oppress them by denying or undermining the exercise of their basic rights, and in particular their civil rights. Doing this sort of thing to one part of society is a typical strategy of unjust oppression throughout human history. This strategy of unjust oppression, after the 14th was ratified, took the particular form of the Jim Crow system, a Southern racist legislative response to Reconstruction. So a basic thought relevant here is this. US society, from the point of view of justice, is only properly conceived as a community of equals, and not as a brutal hierarchy composed of different kinds or types of allegedly different worths. That is, on the correct ideal, US society is supposed not to be a society founded on systematic hierarchy of hereditary special rights and special privileges as in the European feudal order, or as in racist systems like apartheid in 20th century South Africa. We do not believe in marking people out as having different degrees of value or worth based on mere differences like race, sex, gender, social class, ethnicity, sexual orientation, creed, and so on. We take it instead that human people are, at the end of the day, all of a kind and all worthy of equal basic respect and basic protection as such. And these beliefs of ours seem both true and important. Of course, the social reality of US society at the time, propped up and sustained in part by the laws and legal system of states and municipalities, was very far from reflecting this ideal. We are, in my view, still far from realizing it. Given that, there was and is a clear useful role for the federal Constitution, for the 14th Amendment, and for the Equal Protection Clause in particular. It makes for a standing possibility of corrective action against certain recurrent forms of injustice, among them racist injustice, as enshrined in law and social policy. More specifically, when injustice takes the form of law or policy that divides us by establishing or supporting an arbitrary hierarchy, and in particular, by, in effect, restricting or denying the exercise of important basic rights like civil rights, this amendment gives us a way to correct that. In particular, it allows us to address the black codes and the Jim Crow laws, and it was formulated to give us the means to correct and redress injustices of this general kind. This is a simple truth, but this truth raises a puzzle. For the language of the clause does not explicitly mention race or any particular races. Instead, recall, it uses the general notion of persons. Why? Is that a mistake or an accident? Was this just some sloppy vagueness? Is the correct way to think about the meaning of the clause to regard it as limited to and only applicable to address racist injustice of the 19th century, such as the black codes or the subsequent Jim Crow system? So I think pretty clearly not. It's obvious that the force of the clause is broader or more general than that, and this is why it's expressed in terms of persons. So the upshot then of the first point is that the 14th Amendment in general and the Equal Protection Clause in particular was intended to bring us closer to social justice, and it's intended to do so by giving us the means to go about undermining any systematic social injustice of one kind, the sort that depends upon invidious discrimination in the law. That is, discrimination which sustains or supports unjust hierarchy and domination in relation to our basic rights. Now we can be plain about why this is a good thing to constitutionally guarantee. The alternative is allowing one's legal system to be forever vulnerable to being hijacked by this kind of injustice. And this is more or less a standing danger throughout human history, and throughout US history in particular. That's why it's good to guarantee equality before the law. There's a new slide. The second point, this is way more abstract. We can all recognize the difference between A, a law the purpose of which is to undermine people's basic rights and which does in fact undermine them, and B, an otherwise identical law the purpose of which is not to undermine anyone's basic rights, but which does nonetheless in effect undermine the exercise of those rights. Since I'm a philosophy professor, I want to illustrate this by making up an example in the service of clarity. So now I'm going to do that. Take some imaginary democratic society in which all the adults are supposed free by guarantee of their constitution to vote their conscience in any local or national election. Imagine that there's a religious minority community within that society, and that for the members of that community, by their own authorities, one day a month is set aside for religious contemplation and meditation. Let's stipulate that it is by Holy Writ, the third Wednesday of each month. And let's suppose that they're strict practitioners. Nothing civil or secular is to be undertaken on that day. It's for them a holy day. So let that be background. Now compare two laws that might be passed by some local or regional state authority within this society. Law A sets aside the third Wednesday of each month as election day in that state, where the purpose of the law is, wait for it, to depress turnout among the members of this minority community. Law B also sets aside the third Wednesday of each month as election day, but without the above nasty purpose. The lawmakers just happen to settle on that choice with no malice aforethought. Now, what should we say about these imaginary laws in that imaginary society? I think the correct thing to say is this. First, creating and enforcing Law A is clearly worse than is creating and enforcing Law B. We can see that the first is an intentional injustice and the second is an accidental one. Yet, second, either A or B obviously violates the norm of equality before the law. The members of this religious minority community are clearly unjustly burdened with regards to the exercise of their fundamental constitutional right, whichever of these two laws is in effect, and to precisely the same degree. Now, with that in mind, let us turn to the interpretation and implementation of the Equal Protection Clause in connection with our Constitution. It was and remains traditional for the Supreme Court to apply what is called the rational basis test for determining whether any particular state law is in violation of the Equal Protection Clause. This standard requires that in order for a law to count as invalid, it must be recognized as, in its purpose, invidiously discriminatory and not merely accidentally so. By this standard, though, Law B, from our imaginary case a moment ago, would not count as violating equal protection. This is clearly a mistake, it seems to me. Law B, as we imagined it, is a violation of equal rights before the law, but under this standard it would not count that way, so this is a flawed standard. Even worse, the traditional standard is so deferential to state law that it requires the party challenging the law to show that the law's purpose is illegitimate, and that the means are not rationally related to the achievement of some legitimate state purpose. That is, the state need not attempt to justify its action, but instead the party challenging the law must show both illegitimate purpose and lack of rational relation. This would be impossible to show in the case of Law B, and presumably very difficult to show in the case of Law A. In short, there seems to be a fundamental weakness in the traditional attitude of the court towards the Equal Protection Clause. That traditional attitude is wrongly focused on the bad purposes of the law. But as we've seen, substantive injustice can be done in restricting the free exercise of basic rights for some accidentally. What makes it substantively unjust and what makes it a violation of equality before the law is the actual effect on the people in question and the restriction of the free exercise of their basic rights. Whether the law does such injustice as a reflection of its purpose is something of a side issue, or so it seems to me. Now, it's true that real progress was made on this front in the time of the Warren Court. The court decided to adopt an alternative standard first articulated in the 1940s and which is called strict scrutiny. On this standard, the burden of proof shifts to the state authority to justify the law or policy in question, and to do so by showing that its policy or law is necessary to the achievement of a compelling state interest. I accept that this is a considerable advance, but two facts remain. First, the rational basis standard has not been repudiated and remains an available jurisprudential standard. Second, the strict scrutiny standard, well better, seems to have remaining misplaced emphasis. Again, consider the passage of Law B in the imaginary society. That's the more accidental of the two cases. Surely the state can show that it has a compelling state interest in fixing a regular and predictable election, since it does. It can also show that this Law B was narrowly tailored to fit that very purpose, since it was. It can also show that it was not part of its purpose to invidiously discriminate, since it was not. Whether it could succeed in convincing the reviewers that the law is necessary to the achievement of this purpose will depend upon, I say, how clever its lawyers are. For something else is undeniably true. In picking out a day to regularly hold elections, it has done something necessary for holding public elections regularly. Thus, even on the much improved standard, the emphasis is mistaken, and this reveals a weakness in our interpretation of what equality before the law demands of us. What matters are the substantive effects, again, imposing a burden on some, not shared by the rest, where that burden has to do with the exercise of truly fundamental rights. That's where equality before the law is violated. And then the final slide. The third point. So I want to conclude by inviting us to think about what would follow if we embraced a more thoroughgoing commitment to equality before the law, as the Equal Protection Clause seems to demand. First, it seems plain that the 14th Amendment is addressed particularly to the fundamental civil rights of persons as such, and it grants citizenship on the basis of birth or naturalization. The Equal Protection Clause further underwrites broad equity of treatment. This, it seems to me, should have been enough to bring women the vote following the passage of this very amendment. I take it we were correct to read the clause in the broad way we did above, as aiming at justice, and not only one kind of racist, invidious discrimination. That it took more than 50 more years to realize this promise is relatively shameful. Second, it seems clear also that the Equal Protection Clause aims broadly in another way as well, where the laws and system of criminal justice discriminate invidiously not in the language of the statutes, but in the application and administration of the whole system of criminal justice, there too equality before the law is violated. For example, where some people are, in virtue of their skin color and gender, subjected to far greater risk of being caught up in the criminal justice system and to being killed or injured by police on the beat, that too is a violation of equality before the law. And it's past obvious that this is the case for young African American men in particular in our society. This pattern is manifestly monstrously unfair, and we should not tolerate it any longer. We should try to come closer to the ideal reflected in the language of the Equal Protection Clause. Thank you.
Good evening. Before I begin to talk, I always like to know a little bit about my audience, so I'd like to see a show of hands. How many of you there are opposed to discrimination of all types? Please raise your hand. Good. You're always suckered in by that because you're wrong. Discrimination is done all the time, and it's appropriate. Those of you who are students here were discriminated in favor by the College of Wooster by admitting you and not other students. The Cleveland Cavaliers discriminate against me by not allowing me to play instead of allowing LeBron James to play. Your professors discriminate against you by giving some of you an A and some of you a B and some of you a C. There's a phrase called have discriminating tastes. That's a good thing. So don't fall into the trap of saying, I'm opposed to all discrimination. The question is, discrimination on the basis of what? And that's what makes a difference, and that's what we need to focus on when we're talking about the 14th Amendment. The real action of the 14th Amendment is in the first section, and you have that in a handout if you want to look along and take a look at that. And the first part of that says, all persons born or naturalized in the United States and subject to this jurisdiction thereof are citizens of the United States and of the state wherein they reside. The purpose of that was to say that somebody who had been a slave was a citizen. That was the real action that was going on there. But as Donald Trump likes to point out, that means if you're born here, you're a citizen. And so if you travel across the Rio Grande River and your baby is born in the United States, that baby is a U.S. citizen. Now it's becoming very common for mothers from China to come to the United States to deliver their babies so that that baby will be a U.S. citizen. The law, or the language of this amendment couldn't be clearer. If you're born here, you're a citizen. So you've probably heard that if you're paying attention to the presidential election and the primaries, this is why. It's the first section of the 14th Amendment. What else is in Section 1? It says, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. This is what they call the Privileges and Immunities Clause. It doesn't come up a whole lot, but it does sometimes. Next, nor shall any state deprive any person of life, liberty, or property without due process of law. Conveniently enough, called the Due Process Clause. That's extremely important because that basically has to do with what does the government have to do to take something from you. Notice it doesn't say that the state cannot deprive you of life, liberty, or property. It just says they cannot do that without due process of law. You have to have your day in court. You have to have a hearing. You have to have a right to a procedure. That is a fundamental process that is applicable only because of the 14th Amendment. And then finally, it says, nor shall any state deny to any person within its jurisdiction the equal protection of the laws, conveniently called the Equal Protection Clause. And this is what's in the news all the time. Let's talk about that a little bit. Now notice the use of the word state throughout the 14th Amendment, Section 1. Nor shall any state do this, no state shall do that, which would seem to indicate that the 14th Amendment is limited to actions by state governments, right? But let's take a quick detour to the Fifth Amendment. It's part of the Bill of Rights. On the back of your sheet is the entire Bill of Rights. And if you look at the Fifth Amendment, it was adopted in 1791 with the rest of the Bill of Rights, almost simultaneously with the Constitution itself, about 80 years before the 1868 adoption of the 14th Amendment. And the Fifth Amendment, I won't read the whole thing for you there, but it does not have in it an equal protection clause, but you'll see there towards the end where it says, nor be deprived of life, liberty, or property without due process of law. So the Fifth Amendment has a due process clause, kind of like the 14th Amendment. It does not have an equal protection clause. So as part of the Bill of Rights, which was pretty widely thought to apply to action of the federal government, so that would make one think that the Fifth Amendment's application was limited to actions by the federal government. Makes sense, right? That's the whole point of the Bill of Rights, was to limit the national government that was being created by the United States Constitution in the 1700s. Indeed, if you look on your sheet at the First Amendment, it explicitly says Congress shall make no law respecting establishment of religion and so on. The Free Exercise Clause, the Freedom of Speech Clause, the right of assembly, and so on that we take for granted in the First Amendment, it pretty much is it couldn't be clearer. That only applies to actions by Congress, right? It says it right there. It says Congress shall make no law. And while there's this due process clause I mentioned is in the Fifth Amendment, there's no equal protection clause there. So we can agree, can't we, that the Fifth Amendment's application is limited to actions related to the federal government, and the 14th Amendment's application is limited to actions relating to the states. And the two amendments aren't the same, right? It's clear. It's right there in the text. It's in a piece of paper that I just handed out to you. Well, forget about it. That's not it right either. So what happened? First, the Supreme Court held that the Fifth Amendment due process clause should be read as if it had an equal protection component, thus making the Fifth Amendment's application to the federal government indistinguishable from the 14th Amendment's application to the states. Second, the Supreme Court held that the 14th Amendment's due process and equal protection clauses should be read to provide that the two are basically interchangeable. And the Supreme Court held that in any number of cases where the Bill of Rights protections and the 14th Amendment protections were going to be intertwined. So how did they do that? I won't bore you with the technical legal jargon on it, but the consequence of this blending by the Supreme Court, it's called the incorporation doctrine if you want to get technical about it, is that the Bill of Rights, thought to apply only to the states, was incorporated by the 14th Amendment, the Bill of Rights, thought to apply to the federal government, the national government, was incorporated by the 14th Amendment to also apply to the state governments. And remember, when I use the term state government means everything under the state, such as counties, cities, townships, and so on. The townships, states, cities, and so on are a branch of the state government. So when I use the term state government, think of it as everything other than the federal government. So because of this incorporation doctrine, the First Amendment on freedom of speech, religion, and assembly, the Fourth Amendment on prohibition of unreasonable search and seizure, Fifth Amendment on double jeopardy, no self-incrimination, Sixth Amendment on speedy trial, public trial, jury trial, and so on, the Eighth Amendment on the right to bail, and the 14th Amendment due process and equal protection clauses apply throughout the country. It applies to all levels of government. That is a big deal. And it's a big deal because of the 14th Amendment. In other words, these personal freedoms that we take for granted that are ingrained in our being as American citizens of free speech, freedom of religion, limits on search and seizure, privilege against self-incrimination, jury trial, and so on. We all take these for granted, but they permeate our consciousness, and they are mostly unique to the United States. We are different, and I would say better, than Western Europe, Canada, Japan, other industrialized, very Western countries that do not have these kind of protections. And these protections from the government now are pervasive throughout our country because of the 14th Amendment. So let's look a little bit about some Supreme Court cases. These for the most part, will be cases that you're familiar with. And let's start with Brown versus Board of Education, decided in 1954, struck down school segregation, saying that separate but equal is inherently unequal. And questions that flowed from that are, okay, so the Supreme Court said discrimination on the basis of race, saying you're going to go to this school because of your skin color and you're going to go to that school because of your skin color. That was struck down. But is it okay to discriminate on the basis of where you live? Are neighborhood schools permitted? So we're saying if you live in this neighborhood, you're going to go to this school. If you live in that neighborhood, you're going to go to another school. That's discrimination, and is that okay? And that became quite a complicated discussion over the 1970s and 80s when it was hard to distinguish between the overt discrimination on the basis of race and the indirect discrimination on the basis of neighborhoods. A lot of litigation over that issue. Roe v. Wade, 1973, the case that established the constitutional right to abortion. That was not a pure 14th Amendment case, but it's based its holding in part upon the 14th Amendment's liberty and due process clauses in finding the right to an abortion to be a protected privacy right. So whether you think Roe v. Wade was a good decision or a bad decision, the 14th Amendment was a part and parcel of that. Here's a very interesting case. In 1967, and I love the name of this case, it's called Loving versus Virginia. The individual in question, his name was Loving, and the case struck down a ban in the state of Virginia on interracial marriage. Think about that. 1967. I was in high school, Margo was in college, a lot of you out there were alive in 1967. It wasn't that long ago. In many states, it was a crime for people of two different races to marry one another. It was a crime. And in this case, the Supreme Court said no. And the reason was it was a violation of equal protection. It was discrimination that served no purpose. And the hypothetical that Professor Riley gave would answer that as this was like Law B, I think it was, where the law had an improper purpose. Invidious discrimination is the phrase that he used. So as recently as 1967, the Supreme Court said that's a violation of equal protection. And Loving, interestingly, was the very last case. There has not been a case since 1967 that was an overt racial classification like that. There have been plenty of race-based 14th Amendment cases since Loving, but there hasn't been another case where the statute or the regulation in question explicitly said we're going to categorize people on the basis of race in sort of a negative way, if you will. So we have advanced quite a bit, but it's interesting that that wasn't that long ago. In Loving, there's an interesting quote that I will read to you. It's brief. And the Supreme Court said, "There can be no doubt that restricting the freedom to marry solely because of racial classifications violates the central meaning of the Equal Protection Clause. To deny this fundamental freedom on so unsupportable a basis as the racial classifications embodied in these statutes, classifications so directly subversive of the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state's citizens of liberty without due process of law." 1964, a case called Reynolds versus Sims. You probably don't know that name, but you know the result of that case. Reynolds versus Sims struck down electoral district apportionment, saying the 14th Amendment's Equal Protection Clause required every person's vote to be counted equally. In the mid-1960s, as recently as that, again, in Ohio, for example, the state legislature was apportioned on the basis of counties. And so the consequence of that was that rural counties had a grossly disproportionate impact on state legislatures, because if every county had one representative, then the rural areas in southeast Ohio had the same representation as the millions of people in Cleveland. And the Supreme Court struck that down, again, on the basis of equal protection. So the entirety of our government structure today at the state and local level is influenced by the 14th Amendment. And finally, a case you're all familiar with if you've been paying attention to the news at all over the last year, is the case of Obergefell versus Hodges, which is the same-sex marriage case. A 14th Amendment case, plain and simple. The court held that the 14th Amendment was the basis for saying that states must recognize same-sex marriage. Again, let me read a quote to you from the Supreme Court decision in that case in Justice Kennedy's majority opinion. He said, "Under the Due Process Clause of the 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law. The fundamental liberties protected by this clause include most of the rights enumerated in the Bill of Rights. In addition, these liberties extend to certain personal choices central to individual dignity and autonomy, including intimate choices that define personal identity and beliefs. The identification and protection of fundamental rights is an enduring part of the judicial duty to interpret the Constitution. That responsibility, however, has not been reduced to any formula. Rather, it requires courts to exercise reasoned judgment in identifying interests of the person so fundamental that the state must accord them its respect. That process is guided by many of the same considerations relevant to analysis of other constitutional provisions that set forth broad principles rather than specific requirements. History and tradition guide and discipline this inquiry, but do not set its outer boundaries. That method respects our history and learns from it without allowing the past alone to rule the present." Interesting language. So that quote was based on the Due Process Clause of the 14th Amendment. This next clause, quote, is from the Obergefell case dealing with the equal protection portion of the 14th Amendment. I quote, "The right of same-sex couples to marry, that is part of the liberty promised by the 14th Amendment, is derived also from that amendment's guarantee of the equal protection of the laws. The Due Process Clause and the Equal Protection Clause are connected in a profound way, though they set forth independent principles. Rights implicit in liberty and rights secured by equal protection may rest on different precepts and are not always coextensive, yet in some instances each may be instructive as to the meaning and reach of the other. In any particular case, one clause may be thought to capture the essence of the right in a more accurate and comprehensive way, even as the two clauses may converge in the identification and definition of the right. This interrelation of the two principles furthers our understanding of what freedom is and must become. So whether you like the decision or not, it's interesting as a legal matter and as a study of the 14th Amendment that the entirety of the basis of that decision was the 14th Amendment. So in conclusion, I hope I've had some interesting looks here at the text of the 14th Amendment, about some cases that have been based upon it, and I hope you are in agreement with me that because of the 14th Amendment, our country is very different, very, very different than it would have been without it. And if nothing else, I hope your takeaway from this is you will never ever say, I'm opposed to all forms of discrimination. But be clear and say, I'm opposed to discrimination on the basis of, and pick your criteria, and then tell your friends that you support that because you understand that's the 14th Amendment jurisprudence that is appropriate to your thinking. Thank you very much.
Thank you, Margo, and Heather, for a very enlightening presentation. I'd like to start the question and answer session by returning to Dred Scott and Chief Justice Taney. Chief Justice Taney affirmed for this nation that only two classes of individuals could be citizens of the United States. I think that date was 1858. The first were white persons born of descendants who were in the U.S. at the time the Constitution was ratified, and the second class were persons born outside of the United States who migrated here and were naturalized. Blacks could never be free, could never be citizens because they were not considered by the framers of the Constitution. My question is, how did the Dred Scott ruling impact other non-white minorities who had immigrated here to the United States? And secondly, did the 14th Amendment technically extend citizenship to these non-white people?
Well, okay. I don't think it's working.
It should show green.
Now it does. Thank you very much. You're quite right that Dred Scott applied to everybody, but as we've seen in our initial conversations, the pool was limited to begin with. And at that time, there were many other people who were not included. Indentured servants who were white were excluded. Certainly all the people from China who were imported to build railroads were excluded. Many of the people, the Jewish people, many people were simply excluded. What the 14th Amendment did was make it very clear that a person born in the United States became a citizen, and that expanded it to everybody. And that made a great big difference because then you had other immigrants who came who, as we see a lot of the changes in the later part of the 19th century and the 20th century, is as these new immigrants became citizens, had children, and were greatly able to expand the vote and change the direction of politics.
Thank you. I'd like to open it up to the audience. Do you have questions that you'd like to ask?
My question is, I've heard a lot on TV about the 14th Amendment and corporations. And can anybody explain to me how how that works?
Yeah, the 14th Amendment incorporation doctrine is the doctrine that I was referring to when I talked about the Fifth Amendment to the United States Constitution being deemed to apply to the states because of the 14th Amendment and vice versa, that the 14th Amendment incorporated the Bill of Rights into application to the state governments. And there was a debate in the Supreme Court for many years saying that some of the justices said, we're just going to incorporate the Bill of Rights lock, stock, and barrel. That was never done, and it was only done amendment by amendment. And not all 10 amendments of the Bill of Rights have been incorporated, but most of them have, and the key ones, First Amendment, Second Amendment, the Fourth Amendment, search and seizure, Fifth Amendment, self-incrimination, and so on. So incorporation is simply saying the 14th Amendment is taking the Bill of Rights and incorporating that to be applicable to the state governments. So the fact that the search and seizure rules apply to the Worcester Police the same as they do to the FBI is because of the incorporation doctrine.
I think you probably meant more like Citizens United, where in fact over a period of years, and remember where we started, political history includes power and greed. And certainly over the years when it came time for businesses to have civil litigation, any kind of ability to get to court to defend themselves, the treatment of them as persons for that purpose was expanded. They were treated as persons because they pay taxes. Now the expansion of the person right of corporations is very controversial because in this instance of the Citizens United, we're seeing a big sway in large money in political campaigns.
Is that more of your question on, yeah. Yeah, I don't know that I have too much to add beyond what Margo said, but yeah, the Citizens United is a case from the U.S. Supreme Court that, in essence, said that limitations on expenditures for political purposes by corporations and labor unions, any large organization, was prohibited by the First Amendment, freedom of speech. So the Supreme Court has essentially held that speech equals money. And I don't necessarily mean that in a pejorative sense, but just in the sense that in today's age, to get your speech out, you need money. And like it or not, that's been the ruling, and it has had very serious consequences. Some people say good, some people say bad, but there's no question it's had a serious impact. Any other questions in the audience?
So you had mentioned before some of the rhetoric that we've been hearing on the right lately about foreigners or immigrants coming to the United States to have babies here who would be born as citizens. So my question is, could there be any legal backing to get rid of that principle?
Constitutional amendment.
Other than that, because
I don't think so. I've heard arguments by a few people that suggest that Congress could somehow deal with that legislatively, but I don't think so. I think the 14th Amendment is very clear. If you're born here, you're a citizen, period, end of debate. So to change that would take a constitutional amendment, which on that subject is almost impossible to imagine being enacted, because a constitutional amendment, in the normal way of promulgating a constitutional amendment, is passed by 2/3, I think it is, of each house of Congress, and then 3/4 of the state legislatures or something to that effect. That's not going to happen, to do away with that portion of the 14th Amendment anytime soon.
The other part is the next section in the 14th Amendment, which provides that it's subject to the jurisdiction thereof. And a child born in this country, in a state, becomes a citizen, but is also subject to the jurisdiction of that state. And that's a tough clause for anybody to get around. And that's one of the things you'll hear with the political arguments now, where some of the arguments are, well, the reason that the children of illegal immigrants shouldn't be permitted to be citizens, considered citizens, is because their parents are not subject to the jurisdiction of the state. Well, that's sort of a misreading of how the plain language of the amendment is in the first place. But the second point is if you are an immigrant, illegal or otherwise, and you commit a crime, you're subject to the jurisdiction of that state. So I agree with Doug. I think it's going to be very tough. That doesn't mean that there isn't going to be an awful lot of wasted bluster on it.
I thought that the Brown v. Board and Roe v. Wade and Loving v. Virginia were decided because of substantive due process. I'm just confused on that versus deciding on the right of equal protection.
If you're confused by substantive due process, you're in good company, because most lawyers are confused by that. Most judges are confused by that. The concept of substantive due process is very fuzzy and not very well articulated. I don't know if you get into that in your classes at all, but I think you could make a case that those decisions were in part based on substantive due process, but that concept itself, I'm not sure I could give you a shorthand definition of substantive due process right now. But the quotes I read made it pretty clear that the Equal Protection Clause was at least a huge portion of the basis for those decisions. So I wouldn't throw out substantive due process, but as I say, that's a very amorphous concept that is generally used by the courts when they can't think of anything else, but they want to reach a certain result.
Well, there's one more portion to it, and that is if you don't have equal protection, then to get into a court, you're not entitled to due process. Not only procedural due processes, which is what happens if you're arrested and you're entitled to have an attorney, you are entitled to have warrants before people search your houses, but to, in this case, substantive due process. If you're prohibited from being able to commence litigation on an issue that is important to you, that is a denial of substantive due process, and in this case, a violation of equal rights. That's how that worked in this.
Yeah, I didn't want to really add anything too much to that, but it does seem like, I mean, part of Doug's earlier point was, look, you've got to read the Equal Protection Clause, and then if you need to, you might look over at the Due Process Clause and sort of take a little from that and take a little from this, and I think that's what's going on there, right? May not be some help. Yeah.
Let me just ask a question regarding this equal protection. How have the courts squared the idea of equal protection under the law with the historical inequities of unequal protection under the law?
How have the courts?
I will start on that, but then I'm going to hand it to the philosophy professor pretty quickly. I don't know if this is exactly what you wanted to get at there, but if not, it's a good segue to the issue of affirmative action. The concept of affirmative action, that phrase came into being in the early 1960s with an executive order by President Kennedy, who said that federal agencies must take, quote, affirmative action, and that's how that phrase got into our consciousness, to make steps to benefit people who had been discriminated against in the past, especially racial minorities in that time. Go back to Evans' Law A and Law B, where one of those two laws really intended to hurt somebody. Well, this is the flip side of that coin, where affirmative action does discriminate. Again, so don't say you're against all discrimination if you're in favor of affirmative action. And I don't know if you are or you aren't, but affirmative action is discrimination. And what it's saying is it's a benign or it's a beneficial discrimination. Its purpose is thought to be a good one. Therefore, it's to be distinguished from a Loving versus Virginia kind of a law where the discrimination there had no legitimate purpose and was strictly mean-spirited. And so the courts have been back and forth on affirmative action. It's been, the jurisprudence has been pro and con, and the two most recent cases both arose out of the state of Michigan about, let's put a note here, in 2003, and there was a case, Gratz versus Bollinger, that said a point system used by the University of Michigan, where if you were in a racial minority, for example, you automatically got X number of points in the evaluation of whether or not you'd be admitted to the University of Michigan. Supreme Court said, that's no good, that's unconstitutional, it's a quota, that is not an appropriate use of affirmative action, and held that was unconstitutional on equal protection grounds. But in the same year, they decided the case of Grutter versus Bollinger, again from Michigan, from the University of Michigan Law School, if I recall, where the law school there said, we're going to take race as a factor, and it's a plus, and if you're applying to the University of Michigan Law School, we're going to look at your undergraduate grades, we're going to look at your LSAT score, we're going to look at your essay if they had that, and race can be a plus factor. And the Supreme Court said, that's okay. That's a nice use of racial discrimination, I guess you would say. So that's kind of the state of the law today, is that it's okay for race to be a factor, it's not okay for it to be a quota, in terms of what the Supreme Court holdings have been. But you rapidly get into the philosophical discussion, so we'll turn it over to our philosopher.
Right, so I guess the question is, which discriminations are the invidious ones, right? So the way that I understand it, I see it as, well, we don't know exactly which ones are invidious. That's a matter for argument, but there are going to be some cases that are clearly invidious and other ones which aren't, right? So if you've got a law or a social policy or even the administration of a law or social policy that is obviously in the service of an unjust, as I keep using this over and over again, but it's not just coded words, right? An unjust hierarchy, right? A hierarchical domination, that's clearly going to be an invidious discrimination. So then the question is that what's going on with affirmative action? And I think, like, answered honestly, the answer is going to be no, it isn't, right? So it's not violating equal protection. Since you understand equal protection is not, again, to go back to Doug's point, it's not denying the very idea of discrimination. It's not saying discrimination is bad. It's trying to deny invidious discrimination. I mean, that's why I keep sticking the word in front. Of course, right, that itself is a vague concept, right, and it's going to require sort of argument. There are going to be hard cases. But I think, in short, you can be short with this response, right? Not all discrimination is invidious discrimination, and, you know, the sort of case is open for affirmative action. So that's how I see it.
Okay.
Okay. All right. Let's go over here.
I'm thinking not just on affirmative action, I'm thinking of some of the issues that we have today with police brutality and injustices that are meted out within minority communities. Where are the courts with this? I mean, this is a question, I think, that is very much concerning our young people today.
Yeah, I don't know where the courts are with it. I mean, one thing you might say, though, is that it looks like you can violate equality before the law not just in the letter of the statute, but in the administration of the criminal justice system. That seems like a trickier case to make, right? It's, I think, maybe easier to get a hold of language that's explicitly discriminatory. And when you start to talk about policies or administration where the letter of the law is no longer at issue, it's the enforcement that's the problem, it's harder to make the case, right? So I'll hand it over to lawyers for more.
Well, bear in mind again that when you're talking about getting anything to the courts, meaning the Supremes, you're talking about a long time from now before anything in Ferguson, Missouri, or anybody else will get way up there. And in the meantime, what happens is people go to jail. If the state government does not act quickly enough or decisively enough on reining in officers who are acting outside the scope of their duties, you will see that the federal attorney general steps in. Those types of things are not necessarily something that will hit to a court like the Supreme Court unless it is something that is systemically sustained by the state itself. And in the interim, the actors, the individual actors, are going to be arrested and persecuted or prosecuted. I guess persecuted is sort of an even-deven, but prosecuted, and will end up in jail. To the extent that you have states that deal with inaction and are not addressing it, then at some point there may be a systemic claim that eventually will go to the Supreme Court.
Yeah, and Josephine, the way I would answer that question is, in the criminal law context, you don't see equal protection applied too much. And the recent case, I don't know, it was in the last 10 years or so, I can't tell you the name of the case, but there was I thought a pretty compelling argument made in the Supreme Court of the United States that the administration of the death penalty was unconstitutional because the statistical evidence showed it was clearly discriminatory in an invidious sense against black people. And I think any sociologist or criminologist would tell you yes, that is in fact the case, that the statistics are just too overwhelming to be a coincidence. And the argument was made to the Supreme Court, you got to throw out the death penalty because of that. And some of the justices said, yeah, I agree with that, but the majority said, no, you have to look at the individual case. And did this person commit a crime which is worthy of the death penalty, or did he not? And it wasn't a question of whether if Margo committed a crime and I committed a crime, do I need to get the same punishment that she gets? Then the Supreme Court said that's not the right analysis. The analysis is, if I'm the one charged, am I getting the punishment I deserve? And I understand that reasoning, and it may be a slippery slope to go the other direction, but I thought that evidence was pretty compelling, looking at it at more globally. And of course, I'm troubled by the death penalty to begin with, so that may be showing my bias in my thinking on that. But
Thank you.
Thank you all for coming. There are refreshments out in the lobby. Please join us, and the panelists will join us too. Thank you.
Thank you. Yeah.
Thank you.
Awesome. Enjoyed working with you. Yeah. Absolutely.
You all did
We'll get our slides
a
in
lot
order
of
next time.
work. Thank you.
You're very welcome.
Sorry about this.
it happens. Technology.
But you're in old hands.
Technology.
You're able-
Technology happens.